All right, let's get it. All right, guys, happy Thursday. Happy Thursday. Welcome to Purchase Ready Lab Live on a Thursday. Another fun and exciting edition of our theme for this quarter. See you at the closing table. Contract to closing table mastery for Florida Realtors. For those who I have not had an opportunity to meet before, welcome to our lab Thursday office hours. Very good to virtually meet you. My name is Ray Cole Jackson. I'm a South Florida real estate attorney. A little bit about me personally. I always like to kind of just let you know who I am and why I am the one that's having leading the conversation with all of you professional and fine realtors today. Again, my name is Ray Cole. I'm a South Florida real estate attorney. I am originally from South Florida. A little bit about me personally. I attended the University of Florida for undergrad. So I always say go Gators. I went to law school in California, where I was the founder of the Real Estate Law Society. Really started developing my interest and expertise in real estate during my while getting my law degree. I'm always had interest in real estate, but definitely kind of really just went full in once I got to law school, came back home to Miami, got my LLM in real property development. So that's construction, that's from dirt to disposition. So secondarily, go Canes. I am a licensed Florida Realtor and also a licensed Florida loan officer. So when we come into the lab, we are all things real estate from dirt to disposition, from sales to legal to any questions that we have about the process, right? So let me see here, move this over. All right. With that being said, with title being the focus of our training this week or this quarter, our trainings are powered by title experts, our title insurance and settlement services firm. We close all of Florida. So for those who have closings, if you have not had an opportunity to work with us before, many of you, we have had an opportunity to work with you. We continue to work with you. And so it's always a great experience. I mentioned to you guys last week, teaching is a benefit. It goes both ways. Of course, you guys learn and you learn how to do better in your transactions. But guess what? As you guys know, knowledgeable clients are the best clients to have. Knowledgeable clients are the best clients to have. And so, as you guys learn this process, you guys become the best customers, the best realtors for us to work with, right? And so, we always invite the opportunity for to work with the realtors that are part of our lab, right? All right. So, new contracts are sent to closings at titleexperts.com. You can always reach us at 561-510-2294. All right. All right. So where have we been over this quarter? Today is session 6. You can see on the screen where we've been on our closing contract to closing journey. We started off with title in general. We went over the intake process. We went over the title commitment. We went over the lien search. We went over the survey last week, and then this week we are reviewing the Estoppel and discussing HOA violations. So we got a little bit to go, 6 more weeks, but by the time we complete this journey through the closing process, you guys will be very much transaction. You'll be on your way to transaction mastery, right? As it relates to the contract to closing process. So with that being said, you know how we always do about this time. Go ahead and grab the handout. Go grab and grab the handout. Go ahead and grab the handout. What did I just say? Right? PurchaseReadyLabHandout.com, or you can use the QR code on the screen. All right? All right. All right. Florida Realtors Essential Guide to HOA Estoppels, a quick reference to help you understand estoppel requirements, avoid costly delays, and protect your transactions. The Estoppel. The Estoppel. So remember, as a recap, um, the primary searches that are ordered by the closing agent in preparation for closing Our first is title commitment, which we went over, that identifies title issues that are recorded against the property. We order the lien search, which will identify any title issues that are, or potential title issues. Remember, these are not matters with the lien search. These matters are not recorded yet. These are with the municipality. So these are open permits, expired permits, unrecorded code violations. It also, the lien search also tells us about water account balances, and it will also identify any property taxes to be paid. Remember, the closing agent is going to clear title according to the title commitment. The only information on the lien search that they are required to resolve is water bills and property taxes, right? So as it relates to permits, open, expired, unrecorded code violations, that is informational per se, unless you guys include in the contract in the additional term section that seller will be responsible for closing out and resolving all permits and unrecorded code violations at seller's expense prior to closing. That was quick. Someone's gonna say, Ray Cole, can you repeat that? Grab the recording on the lien search trading, all right? Or even listen to this recording, which will be posted on our um, YouTube page, right? So that's the lien search. And then last week we went over the survey. And we know that the survey is going to help us identify and confirm that the real estate itself, the property, and all of its attachments, the fence, the driveway, a shed, for example, that it sits within the boundary lines. It also helps us identify any easements. We went over some different scenarios last week of where a easement can pose a huge issue, right? We also went over making sure that you guys abide by the timing indicated in the contract for raising issues based upon the survey results, right? So that was the fourth search. Today's search that we're going to review is the HOA Estoppel or the Estoppel. Not necessarily HOA because it could be a condo or homeowners association, but we're reviewing the Estoppel today. So, what is an Estoppel? An Estoppel is a certificate issued by a condo or an HOA outlining the operational and the financial requirements of owning a specific property, right? It is a certificate, it is a document that lays out the operational and financial requirements of owning a property in a community that is managed by an association, right? So, um, it's essentially three parts. You're going to see their rules as I call it an abstract. I call it an abstract because it's an abstract, as you know, takes a lot of information and just puts it in a very short document. So as it relates to, for example, their rules for being approved, it's just going to be a couple lines in that HOA estoppel versus what you see on the documents that's recorded against the property, right? So there are rules, the financial standing of that particular property, the financial standing of the association as a whole, as well as the property condition is going to be indicated on that document. All right. You should know that without a clear estoppel, without a clearing the estoppel, everything that's indicated on that estoppel, title insurance, generally the closing agent will not close, right? Because as you guys learned on the title commitment, one of the requirements is an estoppel and complying with the terms of the estoppel, assuming the property is located within a community that is managed by an association. So it ties back to the title commitment. The title agent is not going to order an estoppel unless the title commitment calls for it, right? So I'm going to say that again. The title commitment is going to call for compliance with association rules. The way that the title agent complies with association rules is by ordering an estoppel. An estoppel is an abstract of the association's rules. Right? All right. You guys are title experts already. All right. So, what is identified in an estoppel? First of all, we have financial data and non financial data. Financial data, we find out what are the assessments. In your handout, I included your riders. Your riders have sections in them where you're supposed to disclose to the buyer what the assessments are. Regular assessments, special assessments, right? The estoppel also is going to let us know whether or not there are any late fees pending against the property that needs to be collected at closing. I mentioned is also going to tell us about special assessments. Again, tying back to your riders, in your riders, you should have identified who's responsible for paying that special assessment. Is the seller going to pay it or is the buyer going to pay that special assessment? Right? Transfer fees. Transfer fees is a charge related to transferring ownership of that property to the buyer. The transfer fee is on your purchase contract. It's in section 9, closing costs, and it's under the closing costs that are customarily paid by the buyer, the transfer fee. And then the estoppel fee itself is also going to be indicated on the estoppel. That's the associations or the management company's cost of preparing that document. And the estoppel fee from the contract in paragraph 9 is under the seller section. The seller customarily is responsible for paying that fee. Now, what's some of the non-financial data that the closing agent pulls from the estoppel? Whether or not there are any open violations, right? So the condition of the property. Fences need to be repaired. Fence needs to be pressure cleaned. Fence needs to be removed, or parking violations. There can be violations for parking where it was always existing. One thing I always say about estoppels, I feel like associations often, it's a bit depending upon the management company or the association, sometimes they use it as an opportunity to just clean the deck, right? They just everything they've always wanted this seller to do that they just did not do. Okay, well, you're gonna do it before you sell this property, seller. So they just tie them in, just grab them. Okay, well, we've been telling you about this fence, clean the fence. We've been telling you about this driveway, pressure clean the driveway. We've been telling you about this rickety mailbox, change the mailbox. You'll be surprised some of the things we see on Estoppels, but that's what they get. They get the opportunity to clean house, right? Literally and figuratively at closing. Pending litigation is disclosed in an estoppel. This can be an issue, as you guys know, particularly if it's definitely for condos. Sometimes lenders will pass on if it's a single family home or a townhouse, but the estoppel will let us know whether or not there's pending litigation. Likely, it'll tell us whether or not there are rental restrictions. More of that information is going to come from the buyer looking at the condo docs, right? And then approval requirements. It's going to let us know whether or not association approval is required for a buyer to before closing, and the better estoppels will let us know the status of that approval process, right? Application submitted pending interview, or application not submitted, or interview completed just pending association determination, right? So those estoppels provide a lot of information. Some of them are longer than others. Some of them are shorter than others. If your property is located in a community that has multiple associations, you guys have probably heard the term master association and sub-association. In those cases, it's possible that both of those associations are providing us with an estoppel, and there's going to be a cost for both of those associations. Also, it's possible that there's multiple associations, but that one estoppel will include the information for that sub association. Or last scenario is there are multiple associations, but in that one estoppel is saying that there's no estoppel required for the sub association, right? The last thing I'll say before I move off this slide is, of course, I mentioned to you all previously, the closing agent should be sharing these searches with you as they come out, right? Title commitment goes to everyone. Lien search goes to everyone. Survey goes to the buyer. Estoppel goes to everyone, right? And so when they're sharing these items, make sure you are reviewing them. And we're going to talk about that a little bit further in our discussion today. Now, when is the estoppel ordered? The estoppel is ordered generally immediately after the inspection period. And it's ordered after the inspection period because, again, as I mentioned to you guys, in relation to the survey and the lien search, There, because there's costs associated with it, this is not something that we order as soon as the file is open, because we don't want anyone to incur unnecessary costs. The title commitment is ordered right away. We can control that. That's an expense that is charged to us by our underwriters. We have more flexibility there. But these searches, the lien search, the survey, the title commitment, those are ordered through vendors, right? So they front those costs. They expect to be repaid at closing. That's another thing you should understand. Sometimes we get the question, do I need to pay this now? No, these fees are paid at closing, but we don't want our vendors to incur costs unnecessarily. So, with that being said, the lien search, the survey, the estoppel, they are ordered after the inspection period where we are confirming that the parties are proceeding with the transaction, right? One thing I want to say, so moving to the next point on here is the delivery time frame. The association gets 10 business days to turn that around. So sometimes we'll get the question, well, Rico, can you close in 7 days? The first question I always ask is the property located within an association? Because if you say yes, then definitively, if they allow for a rush, which most of them do, we can close, but you're gonna pay that rush fee, right? But just know that we still have to wait for them to get that over to us. So generally, the association is going to deliver that completed estoppel within 10 business days. If they miss that 10 business days, they lose the right to charge a fee. Years ago, probably maybe 10 years ago now, the legislature got involved with uh, managing these associations and their turn times and their cost, right? So now they have a maximum cost that they can charge. They have a turn time for getting them back. And then there's also a process to be refunded if the transaction does not close, because associations were just brutal in their fees, right? So the last thing is to know that the estoppel is good for 30 days. So why is that important? Most times you're going to close within 30 to 45 days. But if you have a closing where the contract comes in and you're not closing for 60 days, we're not ordering that estoppel until 30 days out. Because if it's ordered, again, that estoppel is only good for 30 days. If the association changes their assessment fee, monthly assessments, or any information changes materially for that association after that 30 days, and we don't get an update, they're going to say, well, that's not our fault. This is only good for 30 days, and you know this is only good for 30 days. So, with that being said, if the estoppel expires, you will be ordering a new one. Some associations are gracious enough to just review it and let you know nothing has changed and to give you a ledger to update the financials. Some say, new order, please. $299 again, please, or whatever their fee is, right? So you want to know that it's good for 30 days. And if for some reason you have a delay and you have to get an update, they could potentially charge. So now we know the timing. How much does an estoppel cost to order? Well, the maximum fee is $299. Um, let's see, we have a question from Jocelyn. What's up?
Uh, does the stubble letter shows the day that it was received, like or the day it was ordered, like when you received the certificate?
Correct. It does have a date on it. You guys should see, and I have it. Let me see. In your example, date completed, October 25th, 2021, page 4 of your handout at the bottom. And they generally send it same day that it's completed. So we don't necessarily have to have an issue where we're like, well, we didn't get it until whenever. They generally send it same day. All right. Good question, Jocelyn. So max fee 299. If the property is in default, delinquent, the association can charge an additional fee to complete that estoppel. And then, of course, the rush delivery fee can also be added to that. So, on average, you're looking at a maximum total of $597 on average, right? Many associations charge less than the 299, but most of them will try and keep it right at the 299. On your example, you will see that the association charged 299 for to complete the estoppel. You'll see that on page 7. All right. All right. So, what about the refund? The generally the estoppel is going to be ordered by the closing agent or the seller's attorney. Earlier on office hours, we talked about seller representation, and we talked about the difference in responsibilities when you have a closing agent and a seller's attorney involved in the transaction. In those cases, you're going to have either the closing agent or the seller's attorney can order the estoppel. If the transaction fails, right, it doesn't close, it's canceled, then with a written request, that cost can be refunded to the party who, and this is an upfront cost. So you guys know the estoppel fee must be paid up front. Even though the seller does not pay it until closing, the party that orders it, they're paying that cost up front. They are refunded in the event that the transaction cancels if the association is notified within 30 days and they provide proper documentation. Generally, that documentation is the fully executed release and cancellation. Fully executed release and cancellation goes to the vendor so that they can share that with the association, and the vendor can be refunded the cost that they paid for the estoppel. Here's a caveat. If the seller orders the estoppel themselves, they cannot be refunded. I don't know why it makes a difference, but that's how the statute is written. That's what you should know. We've never had a seller order their own estoppel anyway, so this generally should never apply in a transaction. But you guys are here to learn about all about it, so there's a detail you should know, right? And then the cost is refunded within 30 days. So, what are some of the issues that arise that could create some issues with closing? Number one is special assessments or what we call surprise special assessments. And they can only be a surprise to the extent that truly this special assessment was not contemplated before you went under contract. We don't, I've not ever really seen that happen. It could be a situation where it was not finalized. The special assessment was not finalized until the parties were under contract. But generally, the property owners have been receiving some communication, letting them know that this is a proposed special assessment. We're going to have a meeting on it. So the seller was aware. So it does not happen very often, but it can happen that you did not document it properly. But now we have when I say document, meaning your writer did not indicate who's responsible. But now now we have default language. For example, that if a box isn't checked, it automatically defaults to I want to say, does it automatically default to the buyer or the seller? Hold on a second. Let me look at your document. It automatically defaults to seller, looks like, on the condo, and if left blank on the writer, I'm sorry, the HOA writer defaults to the buyer. So, contract 101, what? Do not leave blanks. I tell you guys that all the time. There is no reason for a blank on your documents. So, that's that. So, that could create an issue where you now have to have conversations about the special assessments. Open violations. This is probably the more common issue. This and association approval delays are the more common issues. Let's talk about open violations. And we had a great discussion on this again earlier today during office hours. Open violation. Um, Estoppel comes back. Estoppel says that the front door needs to be painted. Front door of the property must be painted. Fine. Of course, when the buyer, you have an as-is contract, of course, the buyer did the walkthrough, they did their inspection, they had no issue with the front door. They realized that the front door needs to be painted. They were going to paint it anyway. Or maybe they didn't intend to paint it, not right away. But the estoppel came back, said that that's a violation that must be resolved. Guys, that must be resolved before closing. Full stop. It must be resolved because the estoppel is a requirement on the title commitment. The title commitment must be cleared so that the title agent can do what? Issue a title insurance policy. Any matter that's a requirement on the title commitment that is not resolved, if it is not made an exception to the policy, meaning we're not responsible for this if you have any issues, if it's not made an exception, it's going to be an issue for the title agent. All right. So I'm going to say that again. If a violation is identified on the estoppel, it has to be resolved because clearing the estoppel is a requirement to clear title. All right. This is separate from a unrecorded code violation or permit. We talked about what that language was about 10 minutes ago. This is separate from that. Even assuming you forget, you have a brain fog, you're moving too fast, and you don't include that additional term language, even without that additional terms language, if the violation is identified in the estoppel, it must be resolved, and it is a responsibility of the seller. Can the buyer assume the violation? Sure, but the closing agent is going to require that they execute a disclosure, and the lender is going to have to be okay with that estoppel becoming an exception to their policy. And remember what I told you guys about that. Most lenders are going to be like, no, no, we're not. Because the same policy is issued, right? The same policy for the lender is issued to the buyer. And remember, when you have a finance transaction, the lender is a partner in that purchase. So whereas the buyer may be saying, it's fine, it's just a gallon of paint, I'll grab it. Don't bother the sellers. It's the last property in America. We'll take it. The lender's like, no, we're not. That needs to be addressed now because that is a requirement on the title commitment. All right. Um, Question is, are associations typically charging max fees and how do they establish their fees? Typically, I would say typically, I would say 50-50. I don't really watch it. I would say about 50-50. Max fee $2.99. Like I said, in our example, the association did charge the $2.99. And how do they establish their fees? Is they pretty much establish it by what they can charge. $2.99 is their max. So you'll see the breakdown in the handout as to what that association charged. All right. Really quickly, going back to violations, because we had this discussion as well during office hours. I just want to pivot. So we do understand that a violation on the property must be resolved if it's identified in the estoppel. With that being said, the buyer, if a violation is identified in the estoppel, the standard to resolve that violation is the association standard. It is not the um it is not um the buyer standard. It is not the buyer standard. All right? So, with that being said, if for example, using the same example, let's say the buyer says, well, I don't want them to just spot paint the door to bring it into compliance. Like say there's paint chips or whatever. And to bring it into compliance, all the association wants is just for those chips to be resolved. Get those spots out of the door. And the buyer says, no, I want the entire door painted. Fresh paint. Do not spot paint it. Well, no, that's not what it is. What it is we're gonna cure the violations according to the association's requirement because now we revert back to this is an as-is contract. This property is in the same condition as it was when you saw it, as when you went under contract. The only reason that we are addressing these chips in the paint on the door is because the association requires it. If this was something that you needed to be done, that should have been addressed when we went under contract or during the inspection. Is that clear? All right. All right. Um, how does Section J self-disclosure relates to HOA violation, especially listed on the estoppel if it does? It does not. So first of all, the seller's disclosure is for items that or issues that are latent, meaning you cannot the buyer is not able to readily see that the paint is chipped, which you can, right? Seller's disclosure as really for the purposes of the contract is for issues that anyone would not be able to see with the naked eye or with performing normal due diligence. So one of the examples I usually use with you guys is, for example, let's say there's a sinkhole in the floor. Remember, I used this hypothetical for you guys. There's a sinkhole under the kitchen table, right? And just by chance, the hole in the floor is under a rug that's under the table. When the inspector comes through, the inspector is not going to remove the table and the rug. But the seller knew it because the seller told you when you dropped your pin at the listing appointment not to go under there because you're going to fall through the floor. That's an example of disclosure related to the contract, what the contract requires. Oh, and by the way, you now are on notice as well. And you need to disclose it because the seller told you, right? So now both of you are on the hook to disclose to this buyer that there's a hole in the floor. That's not apparent. All right. All right. Good question. Um, I think we're good on the transcribing, Rihanna. They're not messing with the recording. The association approval delays. This can be a huge delay. You should know this from the at the outset. What is their turn times? I don't see it as often, or I haven't seen it recently. We usually see it when the community is smaller with a smaller association and a smaller board, that the association is like, yeah, we do interviews on the fourth Tuesday between 2:30 and 2:45. That's it. And you're like, what? And you went under contract, you know, that first Tuesday of the month. And you're like, oh my God, we can't get an interview until the fourth Tuesday of this month. Frustrating, right? Yeah. So, with that being said, you want to know that at the outset. What is their timing? And then, of course, pending litigation. That's important because, again, that could derail your financing. Pending litigation can derail your financing because now we're looking at, we don't know what this association's exposure is, right? What's their exposure pending? What if they're found liable for whatever the matter is, right? So, pending litigation can create an issue for you, and that's identified on the estoppel. All right. All right. So, some quick hypotheticals. Let's say, for example, the seller owes 8 months of HOA dues. And the consequences that the association completely refuses to issue the buyer approval until that balance is satisfied prior to closing. It's possible. It's their docs. It's their association docs, right? So you want to verify balances early. Just talk to them about, are there any past due balances with the association? To your knowledge, are there any violations with the property, right? A $10,000 special assessment is discovered 3 days before closing. How can this happen, Ray Cole? Again, remember, it could happen because maybe you had a short closing period. The association gets 10 business days. That estoppel came in right before closing. That's possible. And we've had it happen before. Because again, you negotiated a short closing period. Estoppel was ordered, but this is when it came in. It came in, and there's a special assessment that was not disclosed when you went under contract. Or there's a special, or there's a I'm not code, there's a HOA violation. That is more common. Or again, approval. So those are the things that come in, and they could come in at the last minute. All right. So again, you want to make sure that you're clear with the seller in advance about whether or not they know anything about special assessments. And then last, we just talked about scenario where the association requires an in-person interview, but the board only meets once a month, fourth Tuesday from 2:30 to 2:45. What are we talking about? Oh my God, are we ever going to close? So what's the consequence of that? Closing is severely delayed, 3 weeks waiting for the board, What is the lesson for you realtors? Understanding or being very much aware of the association's approval process or schedule once you go into contract. So, how do we proactively make sure that we are ahead of any potential issues with the that could arise from the estoppel or concerning the estoppel? First of all, at intake, at listing intake, you want to confirm the association's name and the management company and the management company. The association could not self-manage. They could be managed by they could have a management company. You want to have that information on the rider so that as soon as that contract goes into title, title has the information that they need to order the estoppel at the appropriate time, right? And they're not chasing you down for it. Again, at listing appointment, are there any violations? Are there any excessive unpaid balances that you know of? And then lastly, you want to make sure that where you say, okay, because there is going to be an estoppel ordered. And if there are any violations with the property, if there's any special assessments or any fees associated with or financial requirements with the association that we have not disclosed, we're going to have to address it once we go into contract and we're going from the contract to closing process. Right. So you want to educate your sellers on that in advance. Once you do go under contract, again, you're going to verify if you're the buyer's agent, you're going to verify approval timelines to make sure that you're getting that buyer's application in. And here's the other thing, guys. Some associations they have a very simple application. Some have more cumbersome applications requiring multiple forms. Guys, please make sure your buyers don't piecemeal those forms. We literally have associations like, oh, we're still waiting for the Form A. And you're like, what? What's Form A? So make sure the entire package is completed. Do not piecemeal that, okay? Because they won't even start, they won't start reviewing it until they have a complete application. And then again, if you represent the buyer, you want to make sure that there are no blackout periods. You want to make sure that everybody is available, right, to sign the certificate. I don't know if you've ever had a situation where like, oh, the HOA president is on vacation or he's in Milwaukee or some nonsense like that, but it happens, right? Um, and then immediately after the inspection period, make the application. Make the application. Um, at contract, you also want to make sure that the association rider is complete with the figures because for the and we get into this more when we review the rider. You guys know that let's say for example you say that the association dues are $1 per month and the estoppel comes back and is like nah it's $1,000 per month. Guess what's happening? We're having a conversation because the buyer can cancel. That's because that's not what I signed up for. I signed up for $1 per month, right? Not $1,000 per month, not even $5 per month. So guys, be clear and be certain on what that number is, right? And then lastly, once the estoppel is received, don't just let it come to you or don't even say, "Did y'all get the estoppel? All right, peace out. I'm on to get my next listing." No, make sure that you get it. Make sure that you review it. If you have a transaction coordinator, make sure the transaction coordinator reviews it with you as well. Two sets of eyes are better than one. Make sure that it for the buyer for sure, you want to make sure that you review it. Because yes, the closing agent has a duty to make sure that they comply with the estoppel, but stranger things have happened. What if they missed that violation? Because here's the other thing. These estoppels look different depending upon who completes it, right? Every association, every management company has different templates. And sometimes this information can be hidden and not just clear. And a closing agent can overlook it and they can close with it. And the buyer can go on and they can take title to the property, move in, and the association is knocking on their door saying, "Excuse me, we told you that these paint marks needed to be, or sorry, these chips in the door paint needed to be addressed, and now you're accruing a fine of $100 per day." What? Right? So yes, the title agent has a responsibility, but the information was shared, you should take a look at it as well. All right. All right. Recap. Quick FAQ. That wasn't too painful. 1242. Who orders the estoppel? Typically the closing agent or the seller's attorney. Who pays for it? The as is contract allocates this cost to the seller, but it is negotiable. Remember, I mentioned to you guys last year, what if we're in a seller's, I'm last year, last week, what if we're in a seller's market and the buyer says, I will pay all closing costs? All closing costs can include the estoppel, right? So traditionally, the way the contract is drafted, it is a seller's expense, but it can be negotiated otherwise. Can you close without association approval? You shouldn't. Is it possible? Yes, but you absolutely should not because that is an estoppel requirement. Um, the You should always again review that association estoppel. If it says approval is required, get approval. Does the estoppel guarantee no future assessments? No, it does not. It does not. It only reflects financial standing at the time that it is issued. So a buyer cannot rely on that estoppel and say, well, wait a minute. They said there were no special assessments. I've only been in the property for 30 days, and all of a sudden now they're talking about they're going to do a special assessment now. They can do that, right? And the buyer needs to know that. Can open violations transfer to the buyer? Absolutely yes. Absolutely yes.
But
Under two circumstances. One, where the buyer is knowingly accepting those, and again, that's where the that disclosure it would need to be in writing. But again, now you have a lender who, if it's a finance transaction, they may not go for it. If it's cash, the buyer can do what they want to do with regards to the title policy. But with the lender, they may say, no, you're not accepting that, Peter. No, we're not. All right. All right. So what's our checklist? What's our checklist? We're going to confirm association management details, the contact information at our listing appointment. We're going to ask the seller directly about unpaid balances and no violations. We're going to verify the association's timeline for application review and approval. We're going to push the buyers to submit their application immediately after contract or at least immediately after the inspection period because many of these associations have a fee to apply. So, again, along the same lines of not wanting to spend unnecessary money, we can wait until they get past the buyer get past the inspection period to make that application. Assuming we know the association's timing of approvals, right? If we know the buyer wants the property, come hell or high water, let's just get that application in because we don't want to miss that 2:30 to 2:45 on the fourth Tuesday of the month, right? So get it in. Confirm the estoppel is ordered after the inspection period, right? Just hey, just confirming that the estoppel has been ordered. Because again, we don't want to delay on that. Review the estoppel yourself. Review it yourself. Look for fees, special assessments, violations, and you want to address those violations well before closing day. Well before closing day. All right. This is your handout that you guys got. It's the overview of what we discussed. You want to make sure that you protect your timelines, educate your clients, reduce surprises. Let's look at these questions. Peter, you had your hand up. What's up?
uh, that special assessment.
Yes.
I'm not comfortable with that. We've been in the house 30 days and now, oh, by the way, there's a special assessment. That should have shown up in the minutes of a meeting, right? I mean,
So we're talking about special assessments that are now being discussed by the association, not those that have in fact been levied, but those that are new.
okay, so I can understand if, oh, we're discussing a special assessment, but I'm just like, not, oh, here, by the way, there's a new assessment and you got to pay for this like 30 days later.
No,
That
so
just
what
sounds
I'm saying
shady.
is so we're saying the same thing. So special assessments that have already been discussed, voted on, and imposed by the association, yes, the buyer would know about those prior to closing. I'm mentioning special assessments that are now new special assessments that are now being raised for discussion, vote, and
Okay.
imposition.
Okay, I'm
So
cool
the
with that.
point, so the point, just to close the loop on that, the point in making that using that as an example is to make sure that buyers are aware that just because an estoppel does not indicate a special assessment at closing, they could come up later. Of course, they're gonna have to go through the standard process, but again, you just got to be clear. Buyers, it's their first time. For many of them, it's their first time, especially their first time buying in an association. And some people, like, they've done their numbers. I didn't anticipate having to pay a special assessment, but so they just have to be educated on what that looks like. Um,
Recall on the special assessment,
yes,
even
ma'am.
if one is coming up and it's let's say it's before closing, isn't the seller still responsible for it?
It depends on what you put in your contract. So let's look at your contract. Look at in the handout, we have the writers for Rider B, which is for HOA. And if you go to special assessments, paragraph 2 is where you indicate who's responsible for paying. And then on the condo rider, if you go to paragraph 3, 3C is where we lay out special assessments.
Yeah.
So it's negotiable and it depends upon what the parties have agreed to.
Okay. Thank
Good
you.
on that? All right, good question. And I think Jessica's question is in line with that. Well, you had another one. What would be the process for the buyer to cancel after this executed contract because there's a mistake? It depends on whose mistake it is. If it's a mistake to the extent like the information is incorrect,
Well, you
then
said that the somebody agent put $1 instead of $10 or whatever it was on,
you would notify the seller that the agent that you're canceling because that's not what you agreed to. You
but
agreed
it's
to
already an executed contract.
release a cancellation. That's no different than I'm agreeing to purchase a property for um let's say for example the property is we're under contract for 350 but the property's worth 300 after appraisal. We cancel because in the financing terms it says that the property needs to appraise for 350. So with that rider being a part of the contract, that term of $1 per month is a term of the contract.
Thank you. I just had a win then because I have a closing on the 20th and the appraisal came way higher than what I negotiated.
That's good. That's always good.
Yeah.
That's good. Um, at what point should the listing agent disclose that there's a special assessment? At contract execution, negotiating. Yep. You have to because that's one of your writers. Yep. So that's when that would be discussed. Good question. All right. All right. We didn't know
have a question.
that there was a special assessment. Jessica, is that what you're saying?
Yes, she did not disclose that until we found out
Oh, that's in the
during this.
contract. Well, did you
I was the one that filled out the HO that form.
hold on one second. Who filled it out? You?
I did.
See,
Because
I'm glad you
she
said that
didn't
because I
she
was going to
didn't.
tell you guys that you do not
hmm
fill out the rider. I was going to, the buyer's agent does not fill out the rider.
And normally we are told from my team lead that the listing agent should provide that into the document session in the MLS, but this
Correct.
person did not, and I had to go ahead and fill it out.
Don't ever do it.
Okay.
Require it.
Okay.
I'm glad you mentioned that because I meant to say that and I forgot. Do not, as the buyer's agent, you need to require that the listing agent provides you the completed rider because that's how you hold them to that. Otherwise, it's almost like you're um negotiating against yourself. Like you've tied yourself into something or tied the buyer into a requirement that they and you don't know for sure. Because guess what happens now? So let's use for Sophia's example. So if you as the buyer's agent, you put 340 and it's actually 400. And the listing agent is like, well, you put 400, but of course the seller signed it. So they have essentially agreed to it, but you just don't want to even create that confusion. Because now, what if your buyer is that tight? Because here's, for example, let's say, for example, and Derek can attest to this. Let's say, for example, the association monthly dues are 700. The buyer has their underwriting is for the dues to be 300. Now your numbers are off.
Yeah.
What
That
if you
then
now
comes.
can't what if you now can't qualify because your numbers are off? You see how critical this is? So it's this information weaves into different areas of the transaction.
I never trust their documents, ever. I never trust their documents. I always
Peter
call the
is so
management company
funny.
myself.
Peter is so funny. Helena said that came
Yeah,
in.
you call them to confirm, of course. Yeah.
Yeah,
Because that's the number you're going to put on your contract,
Mm-hmm.
what they tell you.
All right.
Yeah.
I think I hit all the questions. So with that being said, we did good. 12:53. So for those we mentioned last week, for those of you who are not aware, we have a daily contract to closing support room. It's our lab office hours. We kicked it off on Monday. It has been great. It has raised some issues for or some areas for clarity that this Thursday environment is where we learn. We don't, and we do have the Q&A at the end, but you guys have questions obviously that come up in between Thursday to Thursday, number one. Number two, sometimes the timing of it does not allow for us to have as thorough of a response of a back and forth as you would like, as well as including, for example, was able to provide some language today for one of your realtor partners that I would not have had an opportunity to do in this setting. So with that being said, it's a reminder for you guys, our lab office hours is daily from 10:30 to 11. You will access that at labofficehours.com, where you will sign up and you'll get the email reminder and the text message reminder. It has been absolutely phenomenal for those of you who had opportunity to attend. Let your people know. All right. All right. Lastly, I always get questions about where the recordings are. They are on our YouTube channel. If you have not already accessed our YouTube channel and subscribed to Purchase Ready Lab, do that so that you can get notifications when the recordings are uploaded. They're generally uploaded by Friday. If you are not receiving text message reminders, make sure that you scan this QR code. Make sure that your cell phone number is entered, as well as you check box to approve that you get text reminders. Um, and then lastly, if you've not yet had an opportunity, if you found value in these trainings, if you've not had an opportunity to leave us a 5-star review, I'd appreciate it. We are working on our Google review page. Completely forgot about it. Thank you guys so much for those of you who've already given us a 5-star review. For those of you who have not, we would appreciate it. Scan the QR code and leave us a 5-star. All right.
what
You're
QR code am I
welcome.
scanning? Scanning.
It's not scanning
Where's the QR code? I'm sorry.
on the screen. Let me make sure now. Hold on now. Hold on.
Hey, Cole, I have a question while you're
I got
still.
an answer. Possibly. Go ahead. What's up?
Um, Estoppel letter. You also hear that to get an Estoppel letter for proof of down payments or earnest money as well. So is that still a thing? When somebody asks an attorney for the Estoppel letter, have you heard that?
Say that again. An estoppel letter
Is
for.
for to verify the earnest money deposit in an escrow account,
Oh,
perhaps?
the escrow letter.
The escrow, okay, it's not an stop. Okay, so the stop was just for the association then.
Yes, the
Okay,
escrow letter confirms that the deposit has been made. The escrow
okay.
deposit has been made.
And for those, yeah, and for those who have not gone to your YouTube page, it's amazing, man. You got some great information there. It's like, wow. So it definitely, people definitely check that out. You'll be
I
a better
appreciate that.
realtor or loan officer if you do. Thank you.
I appreciate that.
Okay.
All right, guys. All right, guys. So you've been great. I will see some of you tomorrow at 10:30, and others I might see you next week, and others I'll see on Thursday. All right. Let's go sell
Oh,
some
did she
houses.
call?
What's up, Sophia?
Did she call?
I don't see that she called. You want to loop her in on an email? Let me
Give her your email. She's
yeah,
not
loop
gonna
her in on
call.
an
She's not
email.
gonna email.
I don't see
Okay, I'm
that.
speaking to her 1 o'clock. So
Okay, perfect. Yeah,
yeah.
I don't see that